reason for why the Supreme Court of the United States has struck down President Trump's ability to use tariffs. IEPA, they say, the International Emergency Economic Powers Act, does not authorize the president to impose tariffs. This is a judgment from the Chief Justice of the Supreme Court, John Roberts. I'm reading through this decision right now, which just came out literally in the last couple of moments here about the president's tariff authority. Worth noting that this is coming out just before he's set to go in front, of course, of Congress, a joint meeting of Congress, to talk to Democrats and Republicans. He has been touting tariffs constantly. Okay, now I have a good idea of who has joined this opinion. Roberts, the Chief Justice of the court, has delivered the judgment of the court. Also, Sonia Sotomayor, a liberal justice, Alana Kagan, another liberal justice, Neil Gorsuch, a conservative justice appointed by President Donald Trump, Amy Coney Barrett, another justice appointed by President Donald Trump, and Justice Jackson, as well, appointed by Joe Biden, joined that decision.
Hey there, it's Jack, and today's a good one. The Supreme Court has issued a ruling that dismantles the most ambitious claim of unilateral presidential power in modern American history, a single definitive sentence that leaves no room for reinterpretation. The aftershocks are still reverberating through Washington. The Supreme Court has spoken, and what they said will echo through constitutional law for generations. The statutory language cannot support such a burden. 6 words that have effectively destroyed the legal foundation of the most sweeping unilateral economic authority any president has ever claimed. This is not a minor ruling about a technical trade dispute. This is not a narrow decision that only affects one specific program. This is a constitutional earthquake that has fundamentally reshaped the landscape of presidential power across multiple domains simultaneously.
Worth noting that the 2 dissenting judges, Clarence Thomas and Kavanaugh, along with Justice Alito, all dissented from that decision. So pretty fascinating stuff there. The Supreme Court striking down President Trump's tariff policy, something that is not only likely to get a very strong response, to say the least, from President Donald Trump, but also could have a major impact on the current world order. The president imposing sweeping tariffs on nations all across the country, a baseline 10% tariff on countries. And just yesterday, President Trump was in Rome, Georgia, saying that tariffs is the most beautiful word in the dictionary, something he's often said since the campaign trail. He's had this full-throated embrace of tariffs, and now the Supreme Court striking down those tariffs just ahead of the president's most major domestic policy address. I'm just on the president's Truth Social account right now. No reaction from him yet, but we can expect a fairly strong reaction from President Trump, especially given, Steph, and I'll let you weigh in here too, the fact that a number...
Let me take you inside what actually happened. The case involved the International Emergency Economic Powers Act, a statute that grants the president emergency authority during times of national crisis. Trump's legal team had argued that the broad emergency language in this statute gave him the specific authority to impose sweeping reciprocal global tariffs. This authority was broader in scope, covering more countries and more products, and claiming more expansive power than any president had ever previously asserted under this law. It was the most ambitious, unilateral economic authority claim of the modern era. The administration argued that the emergency language was flexible enough to support virtually any economic action the president deemed necessary.
Of the justices that President Trump appointed to the Supreme Court himself joined this decision with the Chief Justice of the Supreme Court appointed by President George W. Bush, striking down the tariffs here. This, of course, going to have massive repercussions. Again, we can expect a very strong response from President Trump. These tariffs have largely been his idea, something that he has championed. He pushed through, in some ways, steamrolling Republican members of Congress, including his own Senate Majority Leader John Thune, who has repeatedly told reporters like myself he's no fan of tariffs, but has been willing to go along with the policy because President Trump has felt so strongly about it. Now, this is probably just going to release a total tidal wave in how things turn around here, in just how the tariff policies could be unwound. Again, a lot of questions about where things go from here, Stephanie. And again, I'm just trying to monitor everything I can to just get a good sense of where things are going. This, of course, just breaking literally in the last couple of seconds here, Steph.
They claimed that national security and economic emergencies justified unilateral action without specific congressional authorization. They argued that the president's inherent Article 2 powers, combined with the statutory emergency language, created a virtually unlimited authority to reshape global trade. But the Supreme Court looked at these arguments and said something that changes everything. The statutory language cannot bear such weight. A 6-3 majority, including 2 Trump nominees in the majority, delivered a ruling that establishes a governing constitutional principle far beyond the specific tariff program at issue.
Hey, Nate. Yeah, I know this is a major decision that we have been waiting for from the Supreme Court. There's a few important things that our audience should note about this decision. One is this does not impact all of the tariffs that President Trump has announced. These are only the tariffs that have been used under IEEPA, which is the acronym for the law the president was using to institute these tariffs. Now, this law has been on the books for decades, but Trump was the first president to try to use this particular law to institute new tariffs. And that is really what the justices were considering here. So there's another major question of what happens to all the tariffs that have already been paid under this statute from President Trump, all of these IEEPA tariffs. Are those funds that have already gone into the U.S. Treasury, are they going to need to be repaid to the importers and to the businesses that have, paid billions of dollars? I think the last update I was looking at recently said that the president's tariffs in totality have brought in as much as $287 billion to the United States Treasury in 2025. Again, not
the Major Questions Doctrine, which requires clear and specific congressional authorization for claims of vast executive authority, has now been explicitly applied to presidential emergency economic powers. This means that future presidents cannot use broadly worded emergency statutes as blank checks for sweeping economic actions. They need clear, specific, and explicit congressional authorization for major economic policy changes. Justice Roberts, writing for the majority, delivered a formulation that constitutional scholars will be citing for decades. The statutory language cannot support such a burden. This is not just about one statute.
All of the president's tariffs are going to be impacted by this decision, but this is going to send major shockwaves through the Trump administration. As you noted, the president likely to be very upset about this decision. You noted the justices who ruled against the president, even some of those justices being appointed by the Trump. But that, I think, speaks to the fact that we have 3 separate and equal branches of government. The justices that are appointed, whether it be Supreme Court justices or your regular federal district judge across the country, you don't want those judges to feel beholden to the president that appoints them. And so this is an example of the judiciary being the independent branch of government that it is supposed to be. I know we've got our legal affairs correspondent, Ava Joy Burnett. I know she is in the office and she, I'm sure, is pouring through this decision as well. And I'm anxious to get her take on what she reads out of this decision. But this is really just a massive ruling that we have been waiting for a few months now. And the question is,
this is about the fundamental principle that major economic policy requires specific statutory authorization rather than implied emergency authority. The court has drawn a clear constitutional line around the executive branch's use of emergency statutory authority. Emergency statutes do not provide implied authorization for the most ambitious exercises of presidential economic power. The practical consequences of this ruling are already visible. The administration has been scrambling to find replacement authority for the tariffs that were struck down. They have pivoted to Section 122 of the Trade Act, a statute with a 15% ceiling, a 150-day limit, a balance of payments justification requirement, and a requirement for congressional extension for any longer duration. Each of those constraints is the specific design of authority that Congress specifically authorized with specific limits attached. The IEPA program operated outside those constraints by claiming that broadly worded emergency language supported uses that the statute cannot bear. The administration is now discovering that the replacement tools are structurally weaker, narrower, and more dependent on congressional cooperation than the program the ruling eliminated. That specific practical governance consequence, the administration being confined to the specific legal tools that Congress has specifically authorized rather than the broadly implied emergency authority it claimed, is the real-world version of the defense obliteration. Not Trump suddenly exposed and desperate in a single cinematic moment, but the executive branch discovering that the specific legally authorized replacement tools available after the ruling are significantly more limited than the unlimited unilateral emergency economic authority the IEA claim had asserted. But the IEPA tariff ruling is only one piece of a much larger constitutional puzzle. Two other pending Supreme Court cases will determine whether the constitutional principles established in the tariff ruling can actually be enforced at the scale the executive branch operates. The nationwide injunctions case and the birthright citizenship case are the specific constitutional fights that will determine whether the courts have both the authority and the capacity to function as effective checks on executive power. The nationwide injunctions case is perhaps the most consequential single pending case for the court's capacity to function as effective checks on executive authority at scale. Federal courts have long issued nationwide injunctions, orders that block an executive action nationwide rather than only in the specific case before that specific court. These injunctions match the scale of the executive actions they block. When an executive order applies to every importer in the country, a nationwide injunction blocking that order matches the scale of the action being challenged. The administration has challenged the federal court's authority to issue these nationwide injunctions. If the Supreme Court limits or eliminates the scope of nationwide injunctions, courts that find executive actions unlawful can only block those actions as applied to the specific plaintiffs before the specific court that issued the ruling. Not nationwide, not for everyone affected by the same unlawful action. Every other person subject to the same unlawful executive action would need to file their own separate lawsuit to obtain the same protection. The practical effect of eliminating nationwide injunctions would be to require every person affected by an unlawful executive action to file a separate lawsuit. A process that could take years for each individual, during which the unlawful action continues to affect everyone who has not yet successfully challenged it. The administration's interest in eliminating nationwide injunctions is transparent. It reduces the court's capacity to enforce constitutional principles against executive actions at the scale those actions operate. If the Supreme Court limits nationwide injunctions, the constitutional principles the court has established, including the cannot support such a burden principle from the tariff ruling, would only be enforceable against specific litigants who have filed specific cases. Everyone else would remain subject to the challenged action. The birthright citizenship case is the other specific pending constitutional fight whose outcome most directly tests whether the court's constitutional authority to say what the law is can be effectively enforced against a president willing to reinterpret 158 years of settled constitutional practice. The executive order challenging birthright citizenship attempts to reinterpret the 14th Amendment's Citizenship Clause, overturning 158 years of settled constitutional practice through unilateral executive action. Multiple federal courts have blocked the order as inconsistent with the 14th Amendment. The administration has challenged both the constitutional merits of the underlying birthright citizenship reinterpretation, arguing that the 14th Amendment's jurisdiction thereof language supports a narrower reading than 158 years of practice has established, and the appropriateness of the nationwide injunctions blocking the order's implementation while the constitutional merits are being litigated. The Supreme Court's resolution of both questions, the constitutional merits of the birthright citizenship reinterpretation, and the scope of the court's authority to issue nationwide injunctions blocking it, will determine the specific constitutional landscape within which the courts can enforce the constitutional limits the second-term executive authority claims are testing. An administration that continues implementing a constitutionally challenged executive order against the full population of affected people while acknowledging the court's authority only in the specific cases of the specific plaintiffs who have successfully challenged it is effectively limiting the reach of the judicial determination to the specific litigants rather than to the full population the challenged action affects. Now let me explain why the combination of these rulings matters so much. Because the cannot support such a burden principle from the tariff ruling, the nationwide injunctions case, and the birthright citizenship case together represent the most comprehensive constitutional challenge to second-term executive authority overreach across multiple domains simultaneously. Each domain, emergency economic authority, citizenship, nationwide judicial remedies, and war powers, is being tested by a specific pending case or recent ruling. Each ruling or outcome will establish a specific constitutional principle governing its domain, and the combination of those principles applied across multiple domains simultaneously is the constitutional landscape within which the second-term executive authority claims are operating. The war powers domain adds another crucial dimension to this landscape. The Senate's War Powers Resolution, passed 50-47, represented a legislative finding that Trump's Iran war lacked the congressional authorization the Constitution requires for war-making. The retired general's war crimes assessments represented the professional military community's finding that specific military conduct violated the laws of armed conflict. And the judicial treatment of challenges to the Iran strikes will determine whether courts will exercise jurisdiction over specific military actions challenged as unconstitutional. If courts apply the major questions doctrine to the war powers context, finding that unilateral war-making without congressional authorization is a claim of vast political and military significance that cannot be sustained under broadly worded Article 2 Commander-in-Chief authority, without clear and specific constitutional authorization, any more than unilateral emergency tariff making could be sustained under broadly worded IEPA authority without clear and specific statutory authorization, the cannot support such a burden principle becomes the governing standard for presidential war powers claims as well as presidential emergency economic claims. This specific extension of the cannot support such a burden principle to the war powers domain would be the most consequential single constitutional development in the accountability story. It would establish that unilateral war-making without congressional authorization violates the same constitutional principle that prohibits unilateral emergency economic action without statutory authorization. The major questions doctrine would apply to claims of executive war powers, just as it applies to claims of executive economic authority. The nuclear option the headline describes is not a single ruling, but the specific combination of rulings that together establish constitutional limits and the enforcement mechanisms that give those limits practical effect. Let me break down what the cannot support such a burden formulation means as a governing principle. Because the Roberts YEPA ruling's specific formulation, the statute cannot support such a burden, is not merely a ruling about IEPA specifically. It is the court's application of the major questions doctrine to the specific context of presidential emergency economic authority. It establishes the constitutional principle that claims of vast economic authority require clear and specific statutory authorization rather than implied authority from broadly worded emergency statutes. This principle applies to every future presidential emergency economic claim that lacks clear congressional authorization, not only to IEPA tariffs, but to any future emergency economic program that a president seeks to implement through broadly worded statutory authority rather than through specific congressional authorization. The nuclear option the headline describes is the specific constitutional principle that the cannot support such a burden formulation establishes. Not just a single ruling about a specific program, but the constitutional governing standard that applies to the entire category of presidential emergency economic authority claims. That governing standard is now in the permanent constitutional record as a Supreme Court precedent. It will be cited in every future challenge to presidential emergency economic authority, and it applies regardless of which president is claiming the authority and regardless of which political party is in power. It is not an anti-Trump ruling. It is the establishment of a governing constitutional principle that will constrain every future president who tries to use emergency statutory language to justify vast economic authority without specific congressional authorization. The major questions doctrine requires the nuclear option. The court's rejection of the broad IEPA authority claim and its establishment of the cannot support such a burden principle represent the most significant limitation on unilateral presidential economic authority in generations. This is not about one president or one statute. This is about the constitutional structure of American governance. The separation of powers, the requirement for congressional authorization for major policy changes, the limits on executive authority. Now let me talk about the nationwide injunctions case and why it matters so much. The specific legal question before the Supreme Court in the nationwide injunctions case, whether federal courts can issue injunctions blocking executive actions nationwide rather than only in the specific case, is the question that most directly determines whether the constitutional principles the court has established can be enforced effectively at the scale the executive branch's actions operate. The IEPA tariff ruling established the constitutional principle that broadly worded emergency statutes do not support claims of vast economic authority. But the tariff ruling was a ruling about a specific program that had already been challenged in a specific case that reached the Supreme Court. If the nationwide injunctions case eliminates or severely limits nationwide injunctive relief, future challenges to executive authority would only protect the specific plaintiffs in the specific case. Everyone else would need to file their own case. The constitutional principle that the executive action is unlawful would be established in the specific case, but its enforcement would be fragmented across thousands of individual cases, each requiring separate litigation by each separately affected person, rather than concentrated in a single nationwide ruling that blocks the unlawful action at the scale it was implemented. The nationwide injunctions case is the specific pending Supreme Court fight whose outcome most directly determines whether the last defense the courts represent is preserved or significantly weakened. If the court preserves nationwide injunctions that cannot support such a burden principle, and every other constitutional limit the court establishes can be enforced at national scale through single nationwide orders. If the court limits nationwide injunctions, enforcement is fragmented across thousands of individual cases in ways that effectively allow the executive branch to continue implementing challenged actions against the full affected population while only acknowledging the court's authority in the specific cases of specific litigants. The birthright citizenship case adds another crucial dimension to this constitutional landscape. The 14th Amendment Citizenship Clause has 158 years of settled interpretation. The executive order attempting to override that interpretation unilaterally is the most direct available second-term test of whether the president can claim the authority to determine constitutional meaning through executive action. The Supreme Court's resolution will establish either that 158 years of settled practice is constitutionally binding regardless of executive action, in which case the cannot support such a burden principle applies to constitutional authority claims as well as statutory ones, and the major questions doctrine's requirement for clear and specific authorization extends to constitutional authority claims and interpretations as well as statutory emergency authority. Or the court will establish that presidential executive authority extends to reinterpreting settled constitutional provisions through executive order, which would be the most dramatic expansion of executive authority in the modern constitutional era. Either outcome will be a landmark constitutional ruling. The cannot support such a burden path would apply the IEPA principle to the constitutional domain. The executive reinterpretation path would be the nuclear option from the administration's perspective, expanding presidential authority into the specific constitutional domain that the amendment process and judicial review are supposed to govern. Now let me bring all of this together. The combination of the IEPA tariff ruling, the nationwide injunctions case, the birthright citizenship case, and the war powers accountability record together constitute the most comprehensive available constitutional challenge to second-term executive authority overreach across multiple domains simultaneously. Each domain, emergency economic authority, citizenship, nationwide judicial remedies, war powers, is being tested by a specific pending case or recent ruling. Each ruling or outcome will establish a specific constitutional principle governing its domain, and the combination of those principles applied across multiple domains simultaneously is the constitutional landscape within which the second-term executive authority claims are operating. The cannot support such a burden principle is the most consequential single sentence in second-term constitutional law. It establishes the governing principle that presidential emergency authority claims of vast economic significance require clear and specific congressional authorization rather than implied authority from broadly worded emergency statutes. The principle applies not only to IEPA tariffs, but to any future emergency economic program that lacks clear statutory authorization. It is the court's specific establishment of the constitutional line that the major questions doctrine draws around the executive branch's use of emergency statutory authority. The line that says emergency statutes do not provide implied authorization for the most ambitious available exercises of presidential economic power. This principle is now in the permanent constitutional record as a Supreme Court precedent. It was established by a court including 3 Trump nominees in the majority. It is binding on every future case involving presidential emergency economic authority claims from any future administration. The cannot support such a burden formulation applies to a Democratic president who wants to use emergency authority for economic programs Congress has not specifically authorized, just as much as it applied to Trump's IEPA tariffs. Because constitutional principles are not partisan instruments, but governing standards that apply regardless of who is president. The nationwide injunctions case is the specific pending Supreme Court fight whose outcome most directly determines whether they cannot support such a burden principle, and every other constitutional principle the court has established can be enforced effectively at the scale the executive branch's actions operate. Constitutional principles that can only be enforced against the specific plaintiffs who have litigated specific cases to the specific courts that ruled in their favor are constitutional principles that the executive branch can effectively work around by implementing its actions against the full affected population while only acknowledging the court's authority in the specific cases of the specific litigants. The nationwide injunctions are the specific legal instrument that extends the constitutional principle to the full affected population. Watch the nationwide injunctions case as a specific determination of whether the court's constitutional authority is effective in practice at the scale the executive branch operates. Whether the IEPA principle and the birthright citizenship constitutional determination and every other constitutional limit the courts establish can be enforced at national scale through single nationwide orders, or whether enforcement is fragmented across thousands of individual cases in ways that effectively allow the executive branch to continue implementing challenged actions against the full affected population, while only acknowledging the court's authority in the specific cases of specific litigants. The birthright citizenship case is the specific pending constitutional test of whether 158 years of settled constitutional practice can be unilaterally overridden by executive order. Its treatment of the nationwide injunctions issue makes it simultaneously a test of whether the judicial determination of the constitutional merits is effective in practice. The 14th Amendment Citizenship Clause has 158 years of settled interpretation. The executive order attempting to override that interpretation unilaterally is the most direct available second-term test of whether the president can claim the authority to determine constitutional meaning through executive action. The nuclear option the headline is describing is a specific combination of the cannot support such a burden ruling and the pending nationwide injunctions case. The court establishing constitutional limits on executive authority through the IEPA ruling, while simultaneously determining through the nationwide injunctions case whether those limits can be enforced at the scale the executive branch operates. If the IEPA principle stands and nationwide injunctions are preserved, the court has both established a constitutional limit and maintained the enforcement mechanism that gives the limit practical effect. If the nationwide injunctions are severely limited, while the IEPA principle stands, the court has established a constitutional limit without maintaining the enforcement mechanism that makes it effective in practice. Establishing the principle in theory, while fragmenting its enforcement across thousands of individual cases in practice. Watch both cases as the specific constitutional determinations that most directly answer the question. The nuclear option headline is asking whether the courts have both the authority and the capacity to function as effective checks on second-term executive authority at the scale that authority is being exercised. The IEPA ruling established the authority. The cannot support such a burden principle is the court's clear statement that it will apply the major questions doctrine to limit emergency economic authority claims without specific congressional authorization. The nationwide injunctions case will determine the enforcement capacity. Whether the courts can enforce that principle at the scale of the executive actions being challenged through single nationwide orders that block challenged actions for every affected person, or whether enforcement is fragmented across thousands of individual cases. The birthright citizenship case will determine whether the cannot support such a burden principle extends to constitutional reinterpretation claims as well as statutory emergency authority claims. The nuclear option that obliterates Trump's last defense in a single dramatic ruling, 9 justices pressing a single constitutional red button, does not exist as a single ruling. It exists as the combination of rulings that together establish the constitutional principle and the enforcement capacity that makes the principle effective in practice. The court has ruled that the statute cannot support Trump's claim, establishing a constitutional principle that could limit unilateral executive power. Whether it's enforceable in practice will be answered by pending cases on injunctions and citizenship. The nuclear option is the cumulative effect of these principles, not a single moment.